Next, discussion on conditions and warranties. Always remember that the presence of conditions and warranties may be waived, and conditions may be considered also as warranties. When is there a warranty? A good tests are the following. 1. If the buyer is ignorant, there is a warranty. If the buyer is expected to have an opinion and the seller has no special opinion thereof, there is no warranty. What is considered to be an express warranty? In the case of parish versus cut-off, the Supreme Court said that an express warranty is defined as it is any affirmation of fact or any promise by the seller relating to the thing if the natural tendency of such affirmation or promise is to induce the buyer to purchase the same, and if the buyer purchased the thing relying thereon. It includes all warranties derived from the language of the contract, so long as the language is expressed. Thus, the warranty may take the form of an affirmation, a promise, or representation. In the case of Azaraga versus Gay, the Supreme Court said that if a purchaser has ample opportunity to investigate the land before purchase, and the seller did not prevent such investigation, and the purchaser really investigates, then the purchaser is not allowed afterwards to say that the vendor made a false representations to him. Next, what is the effect of dealer stock? Ano ba tong dealer stock? Ito yung usually na nangyayari pag bumibili ng kotse. Ganun, di ba? Dealer stock, like excellent, cannot be considered as an express warranty. A little exaggeration is apparently allowed by law as concession to human nature. This is in accordance with the civil law maxim simplex commendatio non obligat, or the principle of caveat emptor. Caveat emptor, or let the buyer be aware. Always remember that in the case of Go Chanko versus Din, the Supreme Court said that where it does not appear that the seller deliberately violated the truth when he stated his belief that there were a certain number of coconut trees on the land, no action will lie against him. Next, implied warranties against eviction and against hidden defect. Your Article 1547 is very, very much important. Okay? This pertains to implied warranties against eviction and against hidden defect. A buyer at a tax sale is supposed to take all the chances because there is no warranty on the part of the state. Okay? And a sheriff does not guarantee title to the property he sells. Another one, in general, the actions based on the implied warranties prescribe in 10 years, since these obligations are imposed by law. Next, warranty in case of eviction. Kindly read your Article 1548. The following are the important points on Article 1548. The warranty in case of eviction is a natural element in the contract of sale. Hence, the vendor answers for eviction even if the contract is silent on this point. The buyer and the seller are, of course, allowed to add, subtract, or suppress this legal obligation on the part of the seller. Thus, it has been held that the vendor's liability for warranty against eviction in a contract of sale is generally waivable and may be renounced by the buyer. Next, although it is true that the government is not liable for the eviction of purchaser at a tax sale, still the owner of the property sold under execution at the instance of the judgment creditor is liable for eviction unless otherwise decreed in the judgment. Next, the buyer is allowed to enforce the warranty against the seller or against the sellers of his own immediate seller. Another point, if the buyer does not appeal from a judgment ordering his eviction and the judgment subsequently becomes final, the seller is still liable for eviction. Last point, even if it was the buyer who instituted the suit against the third person, still the seller would be liable if the buyer is defeated. What is important is that the buyer was defeated. Next, seller's fault. Generally, all rights acquired prior to the sale by others can be imputed to the seller. But imputability or fault is really important. Hence, seller is still liable even if the act be made after the sale. For example, Brian bought the land from Cesario. Brian did not register. Chito then bought same land from Cesario. Chito registers. Brian is defeated. Can Brian hold Cesario liable for the eviction, although Chito's right came after the sale to him? The answer? Yes, of course. Because although it came after the sale, yet it was attributable to the fault of Cesario and there was a bad faith. Remember the following. So very, very, very important. What are the responsibilities of the seller? The seller is responsible for 1. His own acts, 2. Those of his predecessors in interest, and while the following, he is not responsible. 1. So, the seller is not responsible for the following. Number 1, fortuitous events. And number 2, acts imputable to the buyer himself. Okay, next. What are the requirements or essential elements of eviction? 1. First element, there is a final judgment. Number 2, the purchaser has been deprived in whole or in part of the thing sold. 3. Deprivation was by virtue of a right prior to the sale effected by the seller. And lastly, the vendor has been previously notified of the complaint for eviction at the instance of the purchaser. What is a role of the plaintiff in suit? In general, it is only the buyer in good faith who may sue for breach of warranty against eviction. If he knew of a possible dangers, chances are that he assumed the risk of eviction. How about the defendant in suit? In a proper case, the suit for breach can be directed only against the immediate seller, not sellers of the seller, unless, of course, such sellers had promised to warrant in favor of later buyers, or unless the immediate sellers has expressly assigned to the buyer his own right to sue his own seller. Next, kailangan bang yung mga buyer mag-appeal from the decision in order that the vendor or the seller may become liable for eviction? Hindi. Okay? In your Article 1549, it says that if the lower court evicts the buyer, he does not need to appeal to the appellate court before he can sue for damages. However, the decision must of course be final. Next, Article 1550. What is the effect if adverse possession began before the sale? Okay? Kindly read your Article 1550. Next, how about what is the effect of non-payment of taxes? Kindly read your Article 1551. If the property is sold for non-payment of taxes due and not made known to the vendee before the sale, of course, the vendor is liable for eviction. Example, Arthur has land. The taxes on which he has not been paid. Arthur sells it to Ben. Later, the land is sold to public auction for non-payment of tax, and Ben is evicted. Now, because of non-payment, Ben is evicted. Arthur is responsible, but only if Ben did not know at the time of the sale that Arthur had not paid the taxes thereon. Next, Article 1552. In eviction in case of judicial sales. Okay? In the case of Banson versus Standard Oil versus Osario, It has been held universally that in case of failure of title, a purchaser in good faith at a judicial sale is entitled to recover the purchase money from the officer if the funds are still in his hand or from the judgment creditor. Remember that in the case of Bobis versus Provincial Sheriff of Camarines Norte, a buyer at an execution sale acquires nothing if the judgment debtor had already assigned or transferred the property to another before the levy on execution. A sheriff who merely adheres to the terms of a writ of execution is of course not liable for damages. The same is true of the buyer at the public auction. The buyer at an execution sale is purchaser in bad faith if he had prior knowledge of a third-party claim filed with the sheriff before the scheduled execution sale. Article 1553. What is the effect of stipulation waiving liability for eviction? The following are the effects. If seller was in good faith, the exemption is valid, but without prejudice, of course, to Article 1554. If the seller was in good faith, or bad faith, should I say, if the seller was in bad faith, then the stipulation is void. Article 1554 talks about the waiver by the buyer. Okay? Waiver of the buyer, the right to warranty in case of eviction. The waiver of the buyer may have been made. Okay? If the waiver of the buyer may have been made without the knowledge or risk of eviction, and if it is with knowledge of risk of eviction, there are two instances. Okay, it may be without knowledge or with knowledge of the risk of eviction. What are the effects? In case of without knowledge of the risk, okay, in that case, value at the time of eviction should be returned. What is the reason? This is the case of solution indemnity or the undue payment. However, if the waiver by the buyer is with knowledge of risk of evasion, nothing need be returned. This is aleatory in nature, and the buyer assumes the consequences. Article 1555. This is the article that talks about what seller must give in case of eviction. Ano ang mga ibibigay ni seller in case there is an eviction? Okay? We have the shortcut key of or keyword of VICED. 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 V for value, I for income or fruits, C for costs, E for expenses, and D for damages. Of course, with interest, if any. The following are the rules as to income or fruits. If the court does not order the buyer to deliver the income or fruits to the winner, said buyer would be entitled to them. Okay? It is fair for, after all, in the meantime, the seller was using the prize money without interest. Question. Why is rescission not a remedy in case of total eviction? Bakit daw hindi pwede ang cancellation or rescission in case of there is an eviction? The Supreme Court said in the case of Andaya versus Manansala, the remedy of rescission contemplates that the one demanding it is able to return whatever he has received under the contract. And when this cannot be done, rescission cannot be carried out. It is for this reason that the law on sales does not make rescission a remedy in case the vendee or the buyer is totally evicted from the thing sold, for he can no longer restore the subject matter of the sale to the vendor. Of course, in case of partial eviction, rescission may still be allowed with respect only to the subject matter that remains, as in the case contemplated in Article 1556. What is this Article 1556? Okay? The Article 1556 talks about the rules in case of partial eviction. Always remember that in case there is a total eviction, there is nothing to return. Article 1556 talks about rules in case of partial eviction. Again, when there is a total eviction, there is nothing to return. Wala nang ibabalik pag total eviction. Pag partial eviction, the following shall be observed. The remedies. One, of course, is rescission. Kakasabi ko lang kanina. Number 2 is the enforcement of warranty. If the party chooses rescission or cancellation, there should be no new encumbrance like mortgage. Okay? When enforcement of warranty is the proper remedy? If the circumstances set forth in the paragraph 1 of Article 1556 are not present, the only remedy is, of course, to enforce the warranty. 1557 and 1558. 1557 talks about the necessity of final judgment. Remember that final judgment is one of the essential elements of eviction. So, final judgment, the judgment must always be and must be final and executory. In Article 1558, it talks about the necessity of summoning the seller in the suit for eviction of the buyer. The following are the important points. Okay? If you read Article 1558, it talks about the vendor shall not be obliged to make good the proper warranty unless he is summoned in the suit for eviction at the instance of the buyer. Of course, the presence of the vendor is necessary. This is necessary or a condition sine qua non to the case. Remember that the notice must be the notice for the suit for eviction and not the notice in the suit for the breach of warranty. The notice must pertain to the eviction and not to the warranty itself. Okay. Article 1559 talks about this one. The defendant or the buyer shall ask within the time fixed in the rules of court for answering the complaint that the vendor be made a co-defendant. Case. The seller was notified but did not appear. The buyer won in the suit filed by the third person. Can the buyer recover the expenses? Of course not, because there was no breach of warranty. In an eviction suit, it is permissible for the buyer to file a cross claim against the seller for the enforcement of the warranty should the buyer lose. This can be done in some cases to save time and to prevent inconvenience. Of course, if the buyer wins, there is no necessity for the enforcement of the warranty since there has been no breach thereof. Next, Article 1560. Article 1560 talks about the rules in case of non-apparent servitudes. Ano ba itong sinasabi na non-apparent servitudes? Okay? The following shall be observed. The defect contemplated in Article 1560 is really a sort of hidden defect, but remedy is similar to that provided in the case of eviction. The servitudes contemplated are not legal easements, for this exists by virtue of the law. Therefore, it cannot be claimed that the buyer was ignorant thereof. Okay? Remedies. If made within a year, rescission and filing for damages can be made. If after 1 year, rescission is not applicable, but damages can still be filed, or damages can be claimed. What is the effect if burden or easement is registered? There is no remedy if the burden is registered, except if there is an express warranty that the thing is free from all burdens and encumbrances. Next, Article 1561. This talks about the warranty against hidden defects or encumbrances upon the thing sold. What are the requisites to recover because of hidden defects? 1. The defect must be hidden, or one that is not known and could not have been known. Number 2. The defect must exist at the time the sale was made. Number 3. The defect must ordinarily have been excluded from the contract. Another one, the defect must be important or one that renders the thing unfit or useless, or one that decreases fitness. Number 5, the action must be instituted within the statute of limitations or must be brought within 6 months. Next, the notice to vendor within the reasonable time. Ano bang ibig sabihin ng unfit for the use intended? In this unfit for the use intended means that the use must have been stated in the contract itself, or can be inferred from the nature of the object or from the trade or occupation of the buyer. Ano bang sinasabi na dito sa batas na hidden? Sa Tagalog, tago. Okay? One, meaning of hidden. One, what may be hidden with respect to one person may not be hidden with respect to another. Another one, just because there is a difference in grade or quality, it does not necessarily mean that defect is hidden. And lastly, defects are sometimes referred to as redhibitory defects. Next, case. If the buyer examines the tobacco at the time of purchase and questions it only after 3 years, and the seller had not made any misrepresentation, there is no breach of warranty. Remember, the action prescribes in 6 months. 1562. The rule on mercantable quality. Okay? The rule when quantity, not quality, is involved. where the agreement is that all the tobacco in a certain place would be taken, the obligation is absolute and does not depend upon the quality of the tobacco, since here it was not the quality that counted. Article 15, read Article 1563, 1564, and Article 1565. Proceed with Article 1566. Responsibility for hidden defects even if seller was in good faith. Question: why is the seller responsible for hidden defects even if he is in good faith? Answer: because he has to repair the damage done. The object of the law is reparation, not punishment. Thus, for example, if the seller of an unworthy vessel is liable for the hidden defects, even if he did not know of them. Another: seller and buyer agreed that the seller would be exempted from hidden defects, but seller knew of the hidden defects. Would seller be liable? Of course. Seller is liable because of his bad faith. To hold otherwise would legalize fraud. Article 15.7. What are the remedies in case of hidden defects? There are two remedies. Number 1, withdrawal or rescission, or the so-called action redhibitoria plus damages. And number 2, proportionate reduction or action quanti minores or estimatoria, or reduction in the price plus damages. Is this applicable? Is the rule applicable to lease? Yes. The warranty in sales is also applicable to lease. Next question. What is the effect of loss of the thing because of the hidden defects? Note that whether the seller knew or did not know of the defects, he is still responsible. However, in case of ignorance, there will be no liability for damage. Next, what is the effect if it is the cause of loss was a fortuitous event and not the hidden defect? Here, the hidden defect was not the cause of the loss. The cause was either fortuitous event or through the fault of the buyer. The difference would be which represents the price minus the value at loss, represents generally the decrease in value due to the hidden defect. Hence, the amount by which the seller was enriched at the buyer's expense. It is understood then that the decrease in value due to wear and tear should not be compensated. Case: Sheila sold a car for 300,000 to Ben. Unknown to Ben, the car then had a cracked engine block, the replacement of which would cost 175,000 pesos. Despite the knowledge of this defect, obtained a waiver from Ben of latter's right under the warranty against defects. Subsequently, the car was wrecked due to the recklessness of Ben, who only then discovered the defects. What right and to what extent, if any, has Ben against Sheila? Answer: Ben can only recover 175,000 pesos, which represents the difference between the purchase price and the true value. The waiver, of course, is void because Sheila knew the defect. Kindly read 1570 and 1571. Na-discuss na yan. 1572. This talks about the sale of two or more animals together. In this, the following are the important points. Note that generally, a defect in one should not affect the defect. A defect in one should not affect the sale of the other. Okay? Another one is that this is true whether the price was a lump sum or separate for each animal. Of course, this does not apply to team or group. (1574 to 1576), kindly read na lang. What is a redhibitory defect? Kindly read 1576. Question 1577. For what causes of action, if any, does the new civil code provide a period of limitation of 40 days and 6 months? 40 days with respect to redhibitory action based on the frauds or defects of animals, while 6 months with respect to the breach of warranty against hidden defects, rescission of the contract because of the same, or proportionate reduction in the price because of the same. Another is the rescission or proportionate reduction in the price for sale of real estate, either by unit or for lump sum, because of failure to comply with the provisions. What happens if the animal dies within 3 days? Kindly read 1578. What is the remedy of the buyer of animals with respect to redhibitory defect? There are two: withdrawal or rescission plus damages, and proportionate reduction in price. So that ends our discussion with regards to warranty and conditions.